Hello again. Welcome back. We are getting caught up on Miss Sarah Boone today because she has a hearing tomorrow, April 5th, and I want to go through it. So, last video, I talked about what had happened since the video where she got the information on how she was going to get her discovery. Some of you guys may not know how we got to there, how she upped around and found out. It meaning if she thought the judge was the manager, she found out the customer is not always right. But let's go into what happened immediately after that. Well, first, I want to cover a little bit of what the judge's order was because I know people are like, why don't you give her grace? I'm giving her as much grace as I can, but like I said, something is not quite right. Like she's not connecting the dots. Let me see if I can, or maybe I'm misinterpreting. You guys let me know. Oh gosh, where's the judge's order? I think I might have too many. Oh, here we go. Okay. So we have that there. Let's see if StreamYard is going to let me be great here. Make that bigger. So this is page 13 of the 16-page letter. I'm not going to read, or the order. I won't read it all. There's some lawyers on YouTube, like the lawyer you know, and some other folks that have covered it that will explain all the legal bits. But I just want to go into the forfeiture part. Let me see. So forfeiture of right to counsel. A defendant in a criminal case can forfeit a right to court-appointed counsel. A forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation, right? So it's not that she's waived counsel altogether where the judge is saying no counsel can come in. It's just that it is by her behavior, she's no longer is getting court appointed counsel. So forfeiture is a judicial response that adapts the course of the legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. And then they have State versus Nisbet. So, I think calling your lawyer a liar, calling multiple lawyers a liar, saying they're not doing their job, they're not meeting with you. When you finally get one that is meeting with you, then you don't like the way they're meeting it with you, right? She was complaining in that 58 page letter. I was going to try to read it, but there's no way Sugar Bear is going to let me go through 58 pages with y'all. So, but she was like, oh, she is meeting with me, but she won't come and get into a private room with me. She wants to have a video call. And I told her time and time again, there's too many people, or she's not coming enough, or she's not bringing this. It was before it was they weren't meeting with her. Then when they were meeting with her, that wasn't good enough. So I feel like that is manipulation. Like she wants everything exactly her way. And unfortunately, again, the customer, if she considers herself the customer, is not always right. Sis, beggars cannot be choosers. And I'm saying beggar as in you don't have money. When you are paying for your attorney, what you guys agree to or don't agree to is y'all's business. Anyway, as set forth above, defendants' recalcitrance to the attorneys who were not conflicted out. So Padilla, that was the first one. That was the one her husband was paying for, right? Her ex-husband, or she likes to say her former husband, a difference without a distinction. He represented her for 2 years and then filed for withdrawal. Then Bankowitz, that's the one I think we all know and feel sorry for. She called him a dud, a boob, a buffoon, maybe not a boob, maybe a dud and a buffoon. Either way, not nice words, and then was shocked that he wanted to withdraw. Hobson was the brother man. He came in. I thought he was going to do some things. So Bankowitz was looking for this special witness that I believe was domestic violence expert. And then Hobson was looking for the mental health expert. Cashman came in. She had done the deposition. She spent, 20 hours, a little more, a little less in person with Sarah. And she complained about, first she complained with Bankowitz. I have a situation. I'll be right back. Okay, I'm back. Let me make myself larger here. I'm back. So, I don't know what went on with Padilla. Like I said, it was 2 years he was representing her, and then at the end, she said he was incompetent and all these other things. It's like, girl, it took you 2 years to get to incompetent with the man. So then she went to Bankwitz immediately after that and called him all kind of names. He was looking for the DV expert, um, or intimate partner violence expert, depending on who's saying what. Um, then came Hobson. He was looking for the therapist, the psychiatric person, and then Cashman. So she said 20 hours, a little more, a little less. Sarah was complaining about that. So it was never going to be right. And I will tell you, with Bankowitz, who was the first, well, technically the second court appointed attorney, right? She fired the first one, or released, however you want to say it, because Brian, her ex-husband, hired Padilla. So so working with Bankowitz, she started referencing he had been reprimanded by the Florida State Bar for not communicating with clients. So somehow she discovered that's one of her researchers, right? Because she doesn't have access to the internet, but she alleges that she was looking for a contact number for him, or her friend was looking for a contact number for him and stumbled across that. So she kind of threw that out, but I feel like that is a Sarah tactic. And I have some other videos that I'll bring up, like how one of the arrests with George, she brought it up. But if you remember the interrogation, she also brought it up about her neighbors, that they were there. One of the neighbors was there illegally. So she's quick to find dirt on someone and use it against them, right? Like, she's very vindictive. I wonder if the prosecution will use any of that against her. It might be too, like, in the weeds for the jury to consider all those things, but there's definitely manipulation and vindictiveness that Sarah has exhibited, in my opinion, or my 2 cents. We'll figure out what the name of the channel is going to be. I thought it was going to be in my opinion, but I like the alliteration of Tanika's 2 cents. Anyway, I digress. So let me get back to the document that we were reading. Okay, here we go. Just to give you background on all of these. Hobson, she said, lacked communication. He was the quickest one in and out, because I think he already was like, it's you, sis, it's not me. And he also did like a not conflict of interest, it was something else. Basically, like, she was asking him to do things that were either unethical or just flat out illegal. So, okay. So, as set forth above, defendants recalcitrance to the attorneys who were not conflicted out: Padilla, Bankowitz, Hobson, and Cashman. There were the other four were no, three of them were conflicted out. Like I said, the first one she fired. So because they had either represented George or something else had happened, they had been involved in some other way with one or the other of them, so could not rightfully represent her for this issue. Antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, see footnote 9 above, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. So that's below the belt, right? Like, personal attacks. These people are citizens of the legal community, citizens of the community at large, and like, they have a reputation to uphold. You can't just be flagrantly calling them liars as attorneys. So each of these attorneys were required to withdraw. So he's drawn a clear line between your actions resulted in them being required to withdraw, not they just couldn't handle it. Because I think in one of them she referenced, like, one of them wasn't man enough or whatever. It might have been Bankowitz, because he filed twice. The first time the court didn't grant it because she didn't specifically ask for it, and then the second time when she did. So I mean, she hits below the belt. Call it manipulation, call it whatever. It's low, not professional. It has become apparent to the court that defendant will not permit herself to be represented by anyone. See also United States versus Travers. Additionally, the withdrawal of 8 different attorneys, 7 of which were court appointed, leads to a determination that defendant has forfeited his right to counsel. Then he cites case law, Watson versus State, Waller versus State. So I don't know if she read that case law when she was having a hissy fit, but my suggestion would be to read it. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. See Jackson versus State. So because these others are versus State, I'm going to say it's either they appealed. These are defendants who appealed and sued the state saying you did me wrong, or they lost and just took up a whole other suit, because it doesn't say appellate. It's a second district. it might be something DCA, might be appeal. Anyway, don't. I'm not your legal source. There's a lot of people on this YouTube streets that know this is my 2 cents. As the court finds the defendant has forfeited the right to court-appointed counsel under Florida law, there is no obligation to conduct a PERIODT hearing or to otherwise warn a defendant of the dangers of proceeding pro se. And remember, Cashman said you'd have to perform a PERIODT hearing and determine if blah, blah, blah. I'm not sure. I think maybe PERIODT is understanding of like, it's either competency, like to verify they're competent, like, do you know who the president is, or out loud to confirm that they understand they have a right to counsel. They also understand they have a right to represent themselves, like what they did with Daryl Brooks. It's one or the other. The court can find a waiver by conduct to the right to counsel, and it requires that a defendant be warned about the consequences of his conduct, including the risk of proceeding pro se. So February 9th, defendant was twice advised that another court-appointed attorney might not be provided. That was February 9th, 2024. So maybe Sarah was going to say she thought that the judge was crying wolf like George does. On May 10th in 2022, defendant was advised about the dangers of self-representation. On February 9th, defendant was advised about the dangers of this year, February 9th of 2024. She was advised about the dangers of self-representation. As of February 9th, the instant case had been continued 16 times. As of June 26th, the case has been pending 4 years, 3 months, 5 days. That is a little shade, right? Because in all her letters, she has this clock. But yeah, so actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further, right? By at least a year, if somebody else has to come in and get up to speed and continue their caseload, right? And I think that's the thing that Sarah is like confused about. In the beginning, they need to read the discovery, kind of get the lay of the land. Yes, they can talk to her, but it's, for me, if it were me, I would want you to read this stuff before you came to talk to me, so I'm not repeating myself. And then if you have specific questions about what you read, ask me. But it's just like, you know, when you get those phone calls and you're like, hey, this is blah, 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 I need help with. And they're like, please hold. And you go someone else and they're like, how can I help you? And I'm like, yep, still wondering about the help I need. Well, what did you need help with? And then you have to start all over again. You know, I wouldn't want to do it 8 times. So hopefully they read first and then come in, but it's going to take time to read that, continue their caseloads, write motions for their other cases. And honestly, I don't know what the hell she has to talk to. Like, girl, you write a letter. You are a good letter writer. Write it all down, what you need to know. So there's something sus about whatever is these talks that she wants to have. I mean, she talked to Cashman for 20 hours and she still was looking for more talk, more time. I'm curious. Well, now she can just talk to herself and she doesn't have to wait on anybody else. So defendant complains. Oh, wait, to prevent. So encourage. Oh, let me go back. Sorry, I'm talking so much here. Allowing the defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought defendant's attention on May 10th, 2022. So more than 2 years ago at this point. Defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, failed to meet and communicate. And when defendant is provided court-appointed counsel who will meet and communicate, Cashman, the ways and means of meeting and communicating are unacceptable to defendant. Under Florida law, the facts at bar amount to a binding waiver. So the judge granted Cashman's motion to withdraw, shall provide the court. So all of this is happening, and this happened on, let me see, this was the June 28th, and you see it was filed here at 2:47. That doesn't mean that was when the meeting was, but that is when his order was filed. He had created the order before because he talks about reading it during the meeting. So there is that, and then right after that, let me switch out. Me and the sharing. Bear with me, guys. I'm on StreamYard and I don't usually share this much from my other channel. Thank the Lord. So these are the minutes following that meeting. Let me make them bigger. Okay. So I'm going to make myself smaller so you guys can really see this. Okay. The court addressed Attorney Cashman's motion to withdraw. The court read on the record its order dated 6/28 as it relates to the motion to withdraw to the defendant in open court. So Sarah was sitting down, she was placed under oath, and he read out word for word, just like he did in the first one we watched together. He read out word for word what his order was. The defendant gave a statement and asked questions of his order. Asked questions of the court of his order. The defendant was provided a copy of the court's order hand-delivered on that day by Officer Jones and Thomas. The court made findings that the defendant has forfeited her right to counsel. So the motion was granted. This is the part that I want to go to. So all pretrial motions must be filed no later than the close of business on Monday, July 22nd, 2024. So she heard that loud and clear, which is the motions we read in the last video. She understood that. But this part right underneath it, the court ordered Attorney Cashman to provide the 2 boxes of discovery with the clerk marked as identification A and B, which I'm taking that to mean 2 boxes. Sarah says that like it's 20 boxes it's meant to be, but she had 2 boxes. They're marked A and B. I don't know what other reference, or maybe I'm misinterpreting Sarah. The court will reach out to the jail to inquire how to deliver the defendant. So this is important because this went from Cashman to the clerk, not to the court, not to anybody who works in the court's office. It went to the Orange County clerk of the circuit and county court. So she's responsible. She's the clerk of all the courts for Orange County. So civil, federal, or what am I saying? Civil, criminal, circuit, and county courts, right? So it's made clear here that Sarah's going to have to wait. The court will reach out to the jail to inquire how to deliver to the defendant. So even though Cashman left them that day, they still have to figure out this bit, which is she had her lip poked out about. Go figure. Okay. I know you guys hear little man. I'll be right back. Okay, so I'm kind of skipping around, but I'm trying to put them in order where it makes sense. They didn't all come in at the same time, but on that same day that the court had the order where he granted Cashman's withdrawal, where he said that Ms. Boone had forfeited her right to attorney, and he also ordered Cashman to deliver the boxes to the clerk, there is this evidence control sheet. So you, as a true crime fan, I know, as a true crime follower, you know, they always have the chain of custody. So when you have evidence where it started, where it went, to make sure that the chain wasn't broken and the integrity of the contents of the evidence are not impacted. So this, and I want to show, let me make myself smaller here so I can. So this happened the same day that Miss Cashman dropped them off, which was, this is a 6, it kind of looks like a 10, but 6/28, she handed over these boxes. But you see how it wasn't filed until the 9th? So I know Sarah complains about, oh, well, I'm across the street or down the street, but there's a whole process. Like the clerk has other things to do than just to manage the paperwork of Miss Boone. So even though she somehow feels like she's being disadvantaged, this is just the process. I don't know. She just doesn't have that perspective that the world is bigger than she is. Anyway, so here's the 2 boxes, right? Where did we go? Here we go. So Division 20, the judge is Kraynick. This is the case number. The clerk's name. I don't know what this MTW granted. Oh, motion to withdraw granted. So she's turning this over. MTW, I'm pretty sure, is motion to withdraw granted. And so A, box of discovery, B, for the defense. And then it says the court will reach out to the jail to inquire how to deliver to the defendant and will provide written order to release both boxes. So that is telling the clerk, hold on to these. Hold on to them until I give you an order because I need to figure out, George Kraynick, need to figure out how, wait a minute, how to get these to Miss Boone, right? And so that's on 2 documents that he's now said that. I'm sure he said it to her. I don't know if she was thinking about what her questions were or what she was going to answer, that she didn't pay attention, but he definitely said, I got to figure out how to get them to you, right? Okay, so now we're going to go back a little bit. So here we go. Can you guys see that? Oh, no, you can't because I don't have that part of the screen up. Oh, my goodness. So here we go. Let me do this and make this. Now, this is dated June 25th, and she had her other hearing on June 25th. So obviously, this was written before she knew she was going to be no longer provided counsel from the public defender. It was no longer eligible, forfeited, waived counsel that was free. So I shouldn't say free because she could get another pro bono attorney, right? So counsel, court appointed counsel. Let's be intentional with our words. We don't want to be reckless. Okay, so here, this is June 25th. She's saying, and it was not received until the 28th at 2:59, probably filed in while she was in front of the judge, learning that her attorney was granted a withdrawal. So, Your Honor, it was made known to me by an officer here at the Orange County Corrections Department that my attorney, Patricia Cashman, has submitted her motion to withdraw on 6/11, which now explains why she has not contacted me nor answered calls. So that's a contradiction right there, right? Because previously she was saying Cashman wasn't contacting her or wasn't answering calls before. So her not doing so should just be a continuance, right? It shouldn't be something new, but Sarah can't help but be nice, nasty, and then she's telling on herself. Why hasn't anyone sent me a copy so I know? That is a rhetorical question because the judge is not going to answer you. He's not going to be like, Dear Sarah, apologies that we have not been in appropriate contact with you. We are so sorry. Let me explain why. That is not going to happen. I believe, like everyone else, she needs to pay for a copy. Maybe she won't have to do that now that she is pro se. But I know in any other proceedings that I've been in, I had to go down to the clerk's office and get a copy and pay for the copy. And you don't even get it instantly. Like you pay and then they'll call you later. I'm sure you probably can do it online now, but this was way back in the day. So yes, what's going on? To confirm my exclusion in my case, especially by attorney Cashman, she's taking that jab. So especially by her, but not by Hobson, Bankowitz, Padilla, just especially by attorney Cashman, who I feel like attorney Cashman has been, I'm not going to disparage Bankowitz, Padilla, or Hobson, because I don't know. But as far as like presence in court, Cashman has been like the most gung-ho, like, I got this to me. So, and stated in all my letters previously written, I was not included, and I'm finding out weeks later. Judge Kraynick, I am trying to receive, please, a copy of her withdrawal to better understand her reasons for the undisclosed departure from my case. Now, this is rich for me because what do you mean? Like, what does she seriously mean? In court last time, you called the woman a liar. You said she lied. And when the judge asked you, where is the lie? You couldn't even list it. You said, oh, she discouraged your brother, scared your brother off from helping, like being a part of filing for the motion for a bond, which I don't understand that because you have to have somewhere to go. So I think showing like the mortgage and all of that shows that he's a stable person in the community. But she was like, I told her 1,000 times he wasn't the one placing my bond. But where are you going, boo? Like, you have to show ties to the community. And what do you mean when she said 1,000? I'm sure she actually told her 1,000. Anyway, let me get back to this over here before I go on another rant. Let me go while the little man is occupied. So yeah, she doesn't understand from her case. No attempt was made on her part to solve or remedy in some type of discussion professionally beforehand. I would say the same is true for you. I don't think there was a discussion professionally had. You went to the judge, you wrote a 58-page letter, you said she needed to be nice to you. You told the judge that. Just tell her to be nice to me. So, did you have a professional conversation with Ms. Cashman about that beforehand? Maybe she was taking notes from your book. So, therefore, I'm happy to include you for this request as I did with my most recent letter. So, she has to say that because the judge has told her basically, you don't need to write me. And that's what she put in the 58-page letter. And she said it in court. Well, I'm writing you so you know. I'm going to keep writing you so you know what's going on. Hard head, make a soft ass. That's what my mama told me. So please understand, I am trying to understand. With her attempted withdrawal, I think she means withdrawal, my very legitimate concern now is not having all my case contents returned to me, as with most of the prior attorneys. To date, many of my evidentiary case items cannot be located after my numerous requests to the attorney on my case at that time and to Attorney Cashman. No one knows where my case items are, who has what, or cares to research and return now that I am no longer under their representation. I just believe that to be false. Again, based on chain of chain of custody for especially in a murder trial, chain of custody of the evidence. I just find it hard to believe that 3-4 attorneys have just been like, oh, you're not my client. I'm not going to research and return anything. It's going to go in the circular file. I could be wrong. I mean, it could be all these people could, I don't live in Florida. Maybe all of the people are corrupt, or maybe it's Sarah. So shrugged shoulders, avoidance, and lies of where anything may be is all I have received when requesting from former unwilling, disingenuous attorneys. These are my case documents. Attorney Cashman stated to me more than once from me asking repeatedly about that she had reviewed all of my discovery, which I was withheld from reviewing also. So I do not even know all she had specifically and completely and what was available to me. So we already discussed this. Like, was Miss Cashman meant to come down and sit with you while you go through 2 boxes? Like, because she can't leave it with you, as you've stated numerous times. Well, one, it would break the chain of custody, so they have to give you a copy of it. It can't just be in the jail, because you could be like, oh, inmate Lily. Let me make sure I did not lose my sound. Okay, yeah, inmate Lily stole my discovery, and then we're all in a world of trouble, right? So, and the digital stuff, she'd have to sit down there with the computer. But I'm confused because she saw the phone footage that she took during the investigation, and the other things that would be digital would be like her interrogation, her phone interview, or the car interview, and like, you were there, sis. So maybe she wants to see like Brian's interview, or I'm not sure what the digital stuff that she feels, and she doesn't specify. She's just making a blanket claim that she doesn't have all her stuff. So hopefully she can catch someone in the lies that she's always accusing them of. Your Honor, how can I ensure, please, the return of all my case contents from Attorney Cashman? So while this is the day this is being sent and received, she's finding all this out about these discovery boxes that she's gonna have full access to. When may I finally review my discovery and the content she has of my case so I know what is still missing or lost? Um, Again, so she's accusing someone of losing. Wait, baby, or mishandling the are you okay? Or mishandling the oh okay. Oh, okay. Come over here. Can I have a big hug? Thank you. Thank you for the hug. Yes. Yes. Okay, hold on. Again, I just think she's reckless with her mouth, right? Like you're accusing people of things that you don't know to be true. When you're saying it's missing or lost, someone had to take it, misplace it, mishandle it. Who is that person? It's got to be the attorney because they're the only one who has had it. So she has no problem in disparaging people in the same way she's telling the neighbor is here illegally and that she's the only one who knows George and he can't handle his liquor. Never her. It's always somebody else. I find that super interesting. But also notice how nice she's being. Well, nice for her. Please, may I have? When can I finally? Like she's very nice. Even at the top, she calls him the honorable. And I say that because we're gonna get to another letter where he's honorable in quotation marks. So let's see. So missing or lost. Pardon me for having to utilize your invaluable time to ask to receive my invaluable case items. Please understand, I am trying to understand how and when I can fully, rightfully defend myself. Oh, girl, you gonna find out. You didn't effed around. You about to find out. Our due process is due, overdue. I thank you in advance for my inclusion to also receive a copy of Attorney Cashman's withdrawal notice and for helping in the insurity of all my case contents to be returned successfully for my historical review from Cashman. All other former attorneys also, please, if possible. It's all together, Sarah. There's not a Cashman file or this file or that file. I wonder if they're going to give her their own notes. You know how like Daryl Brooks had notes from the prior attorneys and he used that for witness oh my god, questioning. I wonder. So Judge Kraynick, you will never understand my gratitude for listening to me, giving me opportunity to finally be heard, and your apparent caring judicial manner. Thank you immeasurably. Woo! I shouldn't laugh. But it's funny. It is she is nice for a reason, not just for the purpose of being nice. I await the next appropriate step in moving forward, all caps, however, and with whomever. So I await the next appropriate step in moving forward, however, and with whomever. Deuces, that's what it sounds like. For inclusion futuristically and to ensure receipt of all correspondence to me in my case, my address is as follows. This is for legal correspondence only. I'm also including Patricia A. Cashman with a copy of my letter. She puts her address on there. And this was post dated June 26th. So she wrote it on the 25th. It was post dated on the 26th, right? Yeah. And then it was filed on the 28th. Yeah. So it takes time for it to get there. Okay. So she was very, very nice to him, right? So that letter, again, she wrote it. It didn't get to the judge till after he had already sat down with her and Cashman and went over things. So here is her letter subsequent to that. And let me know. I work in corporate America, so maybe it's a different colloquialism. This futuristically, it reminds me of like Mork and Mindy. Like we would say in corporate America, like going forward, I would like to see. We wouldn't say futuristically. What are your thoughts on futuristically outside of Mork and Mindy? Some of y'all are too young to know what that is. Oh yeah. Anyway, that's what it reminds me of. Okay, so let's show this other one. And then I think I'm gonna go play with little man after this. Because he is over it. I think this is the right one. Yes. Okay. Uh-oh, be careful, little one. Oh, uh-oh. So now this one, she's aware. She understands that she's going to be representing herself. She's been told. This is July 8th. So she's not yet had her first pro se appearance, which is where you and I met, I believe. Or no, we met on the 58-page letter that she was about to turn in. So the 58 letter, which help inform the judge that she's run out of chances with court appointed attorneys. All right, let's make this a little bit bigger. And then on this side, make it bigger. And she is out of bounds with this letter. So July 8th, 2024, Honorable Judge Michael Kraynick. So now he's in quotations, which to me means it's questionable, right? Like, because she's not quoting what someone else said. She's making it like, maybe you're honorable, maybe you're not. All right, I'm back. It's much later and I'm losing my light. So I'm going to do this last letter with the honorable. I'm sure a lot of you guys have seen this because I believe this is the one with her want ad in it. But I want to throw in my 2 cents. Now the dogs want attention. I got this one over here. No, not you, baby. I'm talking to Liberty. Oh my God, yes. Let's get to this letter, shall we? Oh Lord, have mercy. Share screen. Okay. So, honorable in quotation marks, Judge Michael Kraynick. Judge Kraynick. No, Liberty. Oh my goodness. The family is trying to keep me from being great. No, get down. If you have dogs and they're barking, I'm sorry. So, Judge Kraynick, where's my discovery? No pretense, no pretext, no, hey, hope you're having a great weekend. She is with it. I am still waiting for you to provide me with the contents of what former attorney Cashman supplied to you and the court at the surprise status hearing held in secret on 6/28/24 at 1:30. This is the other thing that annoys me with one of many things that annoys me with Miss Boone. Now, this one is in secret. The other one that happens after this one, she's her first, when she makes her first appearance as a pro se attorney. Why is how many times has she asked, why is the press here? How did they know? Now this one is in secret. Why? Because the press isn't there. Do you know what I mean? Oh my goodness. The Yorkies. No, Liberty. Hi. So I just like make it make sense, Sarah. Make it make sense. So you your designated clock of unfair judgment ticks empty and incessantly while waiting for you to deliver. So as typical Sarah, it's a misunderstanding. He's not delivering them. And he's not sending them to you. So that's why I wanted to show you those 2 places where he said he was waiting, or he will be communicating with the jail on how to get it to her. In your nonchalant, relaxed, unconcerned attitude of me to receive, you are robbing me of precious life-saving time to fully and properly defend myself on top of my already and still being violated constitutional rights and being forced to represent myself based on false information. Oh, wait, she didn't capitalize false. Based on false information. So this is rich, precious, life-saving time. Like, she has so, like, no self-awareness. She completely lacks self-awareness. That is a poor choice of words, considering what she's being charged with. It was really seconds. Like, she could have saved that man had she just unzipped it before she went up to bed. I do not even know what is contained in said discovery after being withheld from seeing all today. So that we know is a lie because Cashman had already said on the record that when she went to give Sarah another copy of medical records, she could see Sarah's notes in the margin, which also tracks with, oh my gosh, these dogs. Also tracks with Sarah's comments at her last hearing, like she doesn't want a digital copy because she wants to write on the papers, right? So that is tracking. I believe Cashman. And for the first time in said surprise status hearing, um, along with my supposed digital evidence being produced by Cashman, finally, after never being shown any of during her representation, her response to me when I would ask to review was, "Your first attorney said he reviewed with you. That was over 4 years ago. You're my attorney now. You're my attorney now. And no, I did not. This is what I had to deal with. I have not seen it in its entirety and completely to date." For reasons we've outlined. You don't have a computer. She can't drop it off with you. Nobody's going to sit down there and go through 2 boxes and videos and interrogations with you. Do you know? Like, I've watched the interrogations, but not all at once. One, what the Sarah's interrogation, I want to say, is like an hour and a half long. Like, how do you think Miss Cashman is just going to sit down at the jail with you all day? Ma'am, no. And you were there at the interrogation. What exactly is it that you're looking for? Please note, I do not have access to a computer to view these materials. I am doing my very best to figure this and everything else out as I go in my newly unwanted, forced position of pro se. Please do not penalize me even greater than being already. I'm trying. You know, she said she was a straight A student in high school. I would really love to talk to her English teacher, ninth grade English teacher, like before we even get to the literature part, you know? Please know also, I am in an open bay dorm living with 63 other inmates. I also remember, this is me talking, from the interrogation, she wanted to be in an open bay. Remember when she was complaining, like when the lady came with the handcuffs, the deputy, and she was like, "Am I going to be in open bay? Because last time I was in a private cell and I had a panic attack." And I think it was Scott, detective. His first name is Scott. Sorry, sir. I know we didn't sleep together. I don't remember your last name. But he was like, "Well, if you go in acting like this, you should be okay. But basically, if you go in there acting nutty, they're going to put you in the private." So she asked to be in the bay. Now it's a problem. Make it make sense, Sarah. Okay, I'm in open bay living with 63 other inmates. I need to figure out how to view anything securely to avoid further exploitation and mean ignorance. Yeah, I don't think that's a thing that the court can help you with. There is no privacy or individual access in jail. Cashman, I'm glad I could help you shine in the courtroom in front of the judge by you professionally and finally bringing everything I've been asking for since day one. And after I included you, petty, on my letter to the judge ensuring return, unlike you who did not include me on your motion to withdraw. Surprise! And I had to find out from someone else, an officer, 3 days before this surprise status hearing. So you would even know what to bring. English teacher. If anybody knows what school did she go to? Who was her English teacher? Why didn't you bring to any of your 20 hours of meeting with me? As always, it's in everyone else's favor but mine. She didn't have the time or, frankly, the inclination, Sarah. How much real time will I have to prepare and properly, especially the fact you have me doing everything while incarcerated? What happens when more time must be utilized to discover where my lost discovery is? I've been asking for repeatedly, for depositions, to locate my witnesses, contact anyone via collect phone calls. That's a real hurdle. Wait to receive transcripts, any records, everything. I need to finally build my defense. Or is your plan, Your Honor, to just leave me out to dry and in a hurricane? That sounds silly to me, but I read somewhere it's lyrics from a song. I Googled it. I couldn't find the song. So if you know, let me know. because otherwise it just sounds foolish. Hurricanes come with water, man. Your time constraints are extreme and unreasonable. Your decision you claim to have considered from your order is illogical and unfair. Specifically, that it's been malformed by your ignorance and experience of my case. So, to be fair, I know some people were saying like she's calling him ignorant. I think she's specifically clarifying that he's ignorant of the case. Not that that's any better, but I don't think right? Like no sane person would just be calling their judge ignorant. Although I feel like maybe Daryl Brooks, but I don't know if he's sane or not. I mean, I know he was competent to stand trial, but I mean, like really, like a sane person who understands societal constructs. I don't think that's him. And I'm leaning toward like Sarah doesn't really understand societal constructs. So, I mean, listen, maybe she is calling him ignorant, but I'm reading it as your ignorance and experience of my case, which inexperience, not two words. I think she means in, you know how she goes on, but I could be wrong. Misinterpretation, straight lies from the attorneys appointed. They are brazen to stand at your pulpit in your courtroom and commit perjury to your face and the world. But yet, it's me. So I don't know who committed perjury. It would be nice if she could cite specifics, right? He's not at a pulpit. You are not in a church. Separation of church and state, ma'am. It is my belief, and from your order, that actions speak louder than words. So she's quoting him. The court is sabotaging me, forcing me, pressuring me, setting me up for failure. If any of the prior attorneys would have included, cared, collaborated during their time of representation, you not being brainwashed, impartial from believing everyone over me. I'm thinking she's misunderstanding impartial. I don't think you can be brainwashed impartial. You might be partial. He's meant to be impartial. I don't know. And implementing your intricately misconstrued, unfair order formulated from I would not be writing yet another letter. Would I? Wait, what? You not being brainwashed impartial from believing everyone over me and implementing your intricately misconstrued unfair order formulated from, I would not be writing yet another letter, would I? If that is not a true abuser, I'm not even sharing the screen. If that's not a true abuser, I don't know what is. Having been in prior abusive relationships, they will blame you. Your abuser will blame you. Look what you made me do. I wouldn't be doing this if it weren't for your actions. I can't take responsibility for it. She doesn't need to write this letter. The discovery is coming. It's all documented in the court file. In the meantime, while your clock ticks ceaselessly and loud as I wait for you to deliver anything, even more fingers are noticed. They really do point back. Anyway, a lot of fingers should be pointing back at you, Sarah, because this whole letter is you pointing a finger. And I'm defending myself against your inaccurate, libelous, I can write letters to order. Please, would you post my included document in your break room, wherever you think it may be seen and understood, unlike me in your courtroom. Again, with the jabs. Jab, 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 jab. She needs to go round and round with Muhammad Ali. How about by the copy machine, where your JAs should have made me, the news crews, court TV, professional YouTubers and photographers, the world, a copy of the notice of hearing where all aforementioned improprieties occurred, and then some, including the drop off of my case materials, said order being ordered and me being pulled by my uniform to exit your courtroom while still trying to speak and defend myself against all the mayhem and chaos, especially the surprise of even being there unprepared and without notice. I'm not sure why that ends up as a question. How about by the copy machine? I think is where we're going with that. So all of that, it's a lot of commercial fluff. Like just say, can you, and I don't even say put it by the copy machine. I don't think like lawyers are randomly using the same copy machine that the court's JAs are using, JA judicial assistant are using. I don't imagine that the judge has a break room where attorneys are roaming through, because they might accidentally end up mentioning something about a case, and that would be inappropriate, right? Like an ex parte motion. like we saw down in Florida where that judge got had to recuse himself. Judges can't, I mean, lawyers can't talk to judges about their cases unless all parties are present. So that it just sounds weird. Just imagine like the judge. I just don't see the judge having a shared break room. That it sounds weird to me, but maybe she's being funny, maybe she's being serious. Oh wait, my posting, everything supposedly is public record, and there is no notice at all. Another, it's in your favor moment. It's a group effort. Saboteurs. Surprise! I shall return. Nothing is impossible. Believe. Hopeful, grateful, waiting. Thank you for posting. Remember, please, Judge Kraynick, fair, neutral, impartial. You must be always. Okay, Yoda Boone. So there she uses impartial correctly. I'm not sure what she meant in the other one. And then she quotes this, which I have a connection with this. I can do all things through Christ who strengthens me. She's using it incorrectly as I was as a child. I wanted to overcome one of my older brothers, and I was quoting the scripture to do it. It didn't work. I had to go back and reread that scripture. It's not how she's interpreting it. And there is no murder that you're doing through Christ or justifying of. I don't understand why she's pled guilty. I mean, pled innocent. It's her right to plead not guilty. I'm not trying to take that away from her. I don't understand why she's not working toward a deal, because she videotaped herself killing someone and taunting that person. Had she not had the video, she might have had a chance at something else. Maybe manslaughter instead of murder too, but he's dead as a direct result of her action or inaction. He has 3 children that will mourn him, 2 daughters, a disabled son, an ex-wife, a mother, a father, brothers. I saw somewhere where one of his brothers got into a fight with him because of Sarah, and it was something that she kind of cooked up. I'll do some other videos because I do want to like touch on that Sarah is manipulative thread that I hit earlier. Anyway, I'm sure we've all seen this by now, but let's just read it for shits and giggles. Inmate seeks attorney. Looking for a prosperous challenge. Oh, and I know a lot of people were saying she wrote this, and I watched Jumpsuit Pablo to see what his take is, and he didn't mention it either, but I think she paid someone to do this. I've known people who've been in jail and in prison, and like I would get cards from them, and they were fancy and pretty with all the different, scripts in it and roses, and I would always be like, oh, this is so nice, and they'd say, oh, I bought it from inmate so and so who does like calligraphy basically and sells their work, I guess for Zuzums, Wham Whams, Honey Buns, and whatnot. But I am wondering if she actually wrote this herself. I mean, I'm sure she scripted it, but the calligraphy or whatever you want to call it, I'm thinking she paid someone else to do that in Zuzus and Wham Whams. So looking for a prosperous challenge, ready for your close-up on national television? Are you zealous with the side of keen? Show the world who you are with your original creativity, extraordinary expertise, confident ingenuity. Qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills. What is the problem that needs to be solved? Girl, you killed a man. We cannot undo that. We wish we could, but we cannot. Client inclusion at all times, team orientation, collaboration. Like what was the Judge Wooten said, there's some things an attorney gets to decide, and there are some things a client gets to decide, like whether or not to go to trial, whether or not to testify. The rest is up to the attorney. So I don't know what she wants to collaborate on. She's already made it clear she wants to go to trial, and she's probably going to have to testify just because she needs to explain her nonsense, which I've been following some lawyers, and they said basically like she would have to do a narrative. I'm interested to see, because I know in some of the court cases I watch, like the other side will object to narrative, but how else do you question yourself? And Daryl didn't put himself on the stand. So if you guys know of a trial where the pro se person put themselves on the stand, how did that questioning go? I'm curious. Let me know down below, pretty please. Extreme efficiency in listening, communicating, and understanding. So she's not good at listening, definitely not good at communicating. She's like passive aggressive with the little jabs, not clear at understanding, as we've just discussed in this video. The judge clearly said he needed to communicate with the judge and figure out how to get the boxes. And yet in this very letter, she's like, where is my discovery? first sentence out of the box. No decorum. Dedication to success, possessing a winning mindset, capability of excellence and representation, committed. Now, there she might be onto something. She might find someone who is currently committed in an insane asylum or a sanitarium who might be able to help her. Committed might be a good attribute. Maintaining faith, bold, in the client and case with the ability to think differently, overcome all circumstances. So that's very telling when she is saying maintaining faith and she's like bolding it. She feels like her other attorneys did not have faith in her, where in fact it's the other way around. She didn't have faith in them, right? She was like, I don't trust them because they're telling her the truth. That bothers her. That's how I'm interpreting it. And I don't think they have to have faith in you, honestly. Like, they have to understand the dynamics and the facts. And unfortunately, Sarah has a lot of bad facts in her case. And so that's what they have to figure out. There's no overcoming those bad facts or circumstances. There is going through them. I also heard today she was offered at some point 10 years and she turned it down. Well, she would be almost done. She's been in there 4 years now. I don't know why she didn't take that. Well, I have an idea. Anyway, epic opportunity awaits. Sarah Boone, Orange County Corrections Department, invest in the oppressed, believe. I don't believe that she's oppressed. Who's oppressing her? She's oppressed by herself. So I don't think that's technically an oppression. Here's what I think, and these are, again, my 2 cents. I'll come with some receipts of how I got to those 2 cents in the coming days as time and baby boy permit. She is better than everyone else, but she's incredibly insecure, right? Like in her letters, she writes, how do you understand like how invisible, or I can't remember if it was invisible, like, but basically like she feels insignificant, right? How do you think George felt when he was in a suitcase zipped up by his quote unquote lover and begging for his life and being told fuck you? Like, how do you think he felt? Do you think he felt significant? So take a humble pill, ma'am. Take a humble pill. You have to get through this process. And so I feel like, and there are videos where she is like calling the police on him twice in one day and got him arrested. He actually didn't put his hands on her. There was a restraining order, or they don't call it restraining order, but where I'm from in California, they do. I live in New York now, but temporary restraining order. So I'm not sure if it was the TRO or not, but there was some sort of restraining order, temporary. I feel it was temporary pending court. She called that morning on him. He wasn't there. They went looking for him at his parents' house. He wasn't there. Then she called again when he came back, and they arrested him for violating the restraining order. And they told him, hey man, don't come around here. Even if she says, okay, there's still a court order, so don't come around here, because if she calls, we have to come and get you. And he's like getting handcuffs. He was so compliant, so meek. He's a tiny man. He was a tiny man. And he was like, I love you, Sarah. And she was like, I'll do everything I can. But in the video, she comes bounding out of the house like she's excited that they're there. I might be mixing the videos up, so I'll do a reaction to those videos. But there was that. And then there was another time where she called and she wanted to teach him a lesson. And that was the time that she also got arrested, because he kicked her in the eye after she was choking him while he was walking up the stairs. He kicked her so he could breathe. And so I'm not justifying violence either way. This is what the report said. And so her story kept changing, and she was like missing the middle of the story. So it just made it seem like she was lying, because it was like, well, what was going on? And she started this, and this, and then he kicked me. And it was like, well, what? She never mentioned how she strangled him first, right? That came up later. And then he showed the scratches on his neck. So they both got arrested. She references that in her interrogation because she says, well, I got arrested because our stories didn't match. No, ma'am, you got arrested because you lied, right? Your stories didn't match because you didn't mention that you strangled him. So it's more than just the stories. But so she's saying it just enough, like when she's talking with the interrogators, to imply that, hang on, someone's at the... All right, I'm back. If you are still here with me, I appreciate you. I really do, because I got a whole lot going on. Pizza was just delivered. We're going to wrap this up. But so they both got arrested for domestic violence. So, but that's the A to C story that she was doing, or A to Z really, because the middle part implicates, or the middle part of the story of her strangling him, right? And he responded, but she leaves that part out. They came home from the bar. I asked the guy for a cigarette. And as she's saying it, I'm like, she's one of those fun girls. She's too old to be a fun girl now, but she's one of those fun girls, like that super flirty at the bar, hanging out. I might have been this girl at one time, which is why I'm like, oh, is this what's happening? Oh, was that me? But like, he took her lighter or took something. So then she took the cigarette and asked another guy for a light, and he got annoyed. In my mind, she's like flirting with him and like, oh, will you light my cigarette and whatever, and like eyeing and like, honey, because we know she's super touchy, right? The landlord said that. The property manager of like, I would have to tell her to quit touching me. So she could be over there like, oh, honey, can you give me a cigarette and baby? And you probably are like, where are you getting this from? Wait till I show you the video, because she's in the video with the police calling them honey and baby, and she's drunk and they're like, have you been drinking? Oh, I had one glass. So she's that fun time girl that likes to stir up shit. And so that was happening at the bar. So that's what she tells the police. Well, he was mad because another guy was talking to me and then he kicked me in the eye. Never mind the strangle part. Which is in the middle, right? So she skipped that part. That's why she went to jail. She attacked him, number one, and omitted that. That's why their stories were different. But when she retells the story to the detectives, I went to jail because our stories were different. No, you went to jail because you lied and because you put your hands on somebody, ma'am. So yeah, it'll be interesting. It'll be interesting to see like how it all plays out. She's an interesting character. She just really is, and she is always the victim. There's a lot. We're going to cover it all. Like there's stuff going on with her husband. I want to talk about it. I'm tired of being in other people's chats talking about it, because sometimes I have questions and things I want to say, and I want to be respectful of other people's chats. So we could just chat over here. If you are so inclined. But like I said, I appreciate you. Thank you. Oh, you know what? I want to play one more thing, because like this reminds me of Miss Sarah. Let me see. And then I'm going to go, I promise. Wait. Stop the screen share screen. Also share audio. Okay. Let me make sure this audio is loud. She's never satisfied. Why do we scream? Yes, she's never satisfied. I feel like the whole When Doves Cry is Sarah and George. Just, it was bound to happen. One of them was going to kill the other one. They did not seek help. I can't think of a better example of a more toxic relationship. And they claim to love each other. Yep. All right. I will talk to you guys later. I appreciate you hanging out with me. Bye.